Hey everyone, it's Laura here from TheRealLauraB here on YouTube and on Twitter. I have the final reply from Travelers. Remember, this is the insurance lawsuits between Travelers and New York. And then we have New York suing Amber Heard, and Travelers wanted to consolidate both lawsuits. So they filed to consolidate. New York Marine opposed it. We haven't heard officially from Amber Heard's counsel yet. I think she's been served based on the little notations I've seen. But they came back in an email saying, hold up, wait a second. We're not sure this is good for our client. We need to do some more investigation. New York, that's what New York Marine replied with and said, wait, it may not be good for them. It's confused the jury if they're hearing both cases at the same time. Yes, there might be some duplicate depositions, and maybe we can work that out together. But overall, we don't want this consolidated. And that's pretty much where it was left. And then Travelers now they filed, New York Marine answered, Travelers has the final answer, although I think Amber Heard eventually will reply onto this. She still has not filed her answer to the New York Marine lawsuit against her. But anyway, that's what we're going to be covering today. So let's get started.
Hi, I'm Laura, also known as TheRealLauraB from Twitter, and now here on YouTube. I'm a researcher, new wave internet media, and commentator. I'm not a lawyer nor offering any legal advice. Join me on a journey to review the world of celebrity lawsuits and current events. Let's get started.
And here we go. Another thing that New York Marine cited in their reply to the opposing the consolidation was, hey, we haven't heard your answer, Travelers. Amber's counsel said, hey, we're asking you both to stop this right now. Hold off. Give us a chance to look this over. The email was shared at the same time with both New York Marine and Travelers. And New York Marine claims Travelers never answered. So we don't know if you were going to stay your opposition or not. So Travelers is now coming back with their answers. And I'm wondering if there's some gamemanship going on here. Let's take a look. So Travelers did file this on September 30th while I was traveling. And this is the plaintiff Travelers Commercial Insurance Company reply brief, remotion to consolidate its action with action filed by defendant New York Marine General Company against the insured, which is against Amber Heard. So they want to combine them. Now, what I will say, just as a reminder, the two lawsuits were already transferred and assigned to the same judge. So this is the second lawsuit. So there's the first complaint, and the second complaint is with Amber Heard. And this is what they have to say. In opposing the motion of plaintiff Travelers Commercial Insurance Company, Travelers, to consolidate two actions pending before this court, defendant New York Marine and General Insurance Company, ProSite, concede the main point that the actions substantially overlap. ProSite makes two arguments against consolidation, that the two cases are not identical, and two, that we need to first hear from the insured who is the defendant in one of the actions, Amber Heard. Neither argument is a reason to deny consolidation. The court should order the two cases consolidated. Consolidation does not require identical actions, but merely common questions, which ProSite does not deny exist here. The majority of ProSite's opposition discusses issues that are present in one action or another that ProSite asserts are not common. For example, ProSite notes that Travelers' rights and obligations are not at issue in the dispute between ProSite and the insured. ProSite offers a tortured analysis of the issues in both cases, and it ignores the close relationship between the rights of Travelers and Amber Heard. Travelers' rights against ProSite are tightly intertwined with and dependent upon the scope of ProSite's obligations to the insured. In other words, the court or other trier of fact cannot determine the respective rights of Travelers and ProSite without also considering the rights of the insured, Amber Heard, against ProSite. And I think that's an interesting statement here by Travelers and ProSite without also considering the rights of Amber Heard. There's a reason I think there's a little gamemanship going on here, that Travelers wants Amber Heard in their case. Let's take a look. There was a hearing for dismissal, and the judge did pretty much dismiss Travelers' claims that New York Marine was obligated to let Amber Heard hire her own counsel. The court disagreed and said, nope, New York Marine could appoint counsel. As it happens, they appointed Cameron McAvoy, who Amber Heard had already hired. Here's what the court has to say about travelers claiming that Cameron McAvoy didn't do their job. Court, in other words, if it is just a mere situation that Virginia counsel was either negligent or insufficient, but without any prearrangement on the part of the defendant, the plaintiff wouldn't have standing, because again, the deficient performance would be performance that was due to the insured, due to Amber Heard in that situation, and not to the plaintiff. So the issue is, if Travelers is trying to say that Cameron McAvoy did a terrible job as a lawyer in representing Amber Heard, well, that's not on Travelers. They can't claim that. That has to be Amber Heard. But if they're claiming that Cameron McAvoy themselves intentionally did no work and only rode on the coattails of Robbie Kaplan or Ben Rottenborn or Elaine Braderhoft, then Travelers might have a statement. But they can't say just generally that Cameron McAvoy did a bad job. Only the insured can do that. Only the insured, Amber Heard, can claim insufficient or negligent representation. And I think that's why Travelers might be trying to get Amber Heard into their lawsuit and doing that by way of consolidation. So let's continue here. In other words, the court or other trier of fact cannot determine the respective rights of Travelers and Prosite without also considering the rights of Amber Heard against Prosite. The court's assessment of the interrelated rights of the three parties should not be done twice, with the potential for two possibly differing results. Rule 42 of the Federal Rules of Civil Procedure does not require identicality of claims or issues, but rather there be a common question of law or fact. There is no mention of identicality or the absence of uncommon issues, as Prosite implies. It is impractical to imagine that two cases would present entirely identical factual or legal issues. That is likely why that is not the standard. The existence of some additional questions or issues is not a reason to deny consolidation. Prosite's opposition mentions a line of cases that state that consolidation is inappropriate if it results in inefficiency, inconvenience, or unfair prejudice. True enough. However, Prosite does not then establish that we see that here. Prosite, who is New York Marine, by the way, they go by both names. Prosite does not argue, and it is hard to see how it could, that litigating one consolidated case would be inefficient or inconvenient to it. As the common party to both cases, it would be absurd for Prosite to argue that it would be more convenient or efficient for it to manage two separate lawsuits, which involving overlapping issues rather than one. The overlapping issue, just to mention real quickly, Travelers is suing New York Marine because they didn't pay for half their costs. Travelers ended up paying the whole bill. New York Marine says, too bad. We provided counsel first. We provided the counsel Amber Heard had selected. We agreed to pay their fees. You didn't want to work with our counsel. You brought on another counsel. We're not obligated to pay your counsels. Then we find out your counsel refused to work with our counsel. Our counsel is being left out of the motions, out of any of the meetings, any of the strategy sessions. And they said, you know what? If something goes wrong and Amber Heard sues for ineffective defense, we had no say in her defense, and we don't want to be sued. So since they're not letting us do our job, we're going to bow out. So they withdrew, and Amber Heard allowed that. Travelers then contended, well, New York Marine should then pay half of our lawyers' costs. So they negotiated how much they should pay. And Travelers said they would cap the fees at $2.5 million because they're supposed to be paying the local rates, not just whatever Elaine Braderhoft charges. Well, they blew through the $2.5 million cap a year before the trial even came. And New York Marine says, no, we're not. First of all, we'll pay 50% of normal, reasonable costs in Virginia, but you have to give us all the receipts. You have to show us everything. And that's where they did provide a certain amount of money, 50%. But then Travelers was no longer providing them with receipts. Well, the trial happened, and Amber Heard was found not just liable in the lawsuit, but with actual malice, which is an intentional tort. She lied. She knowingly lied. And New York Marine now is going, whoops, wait a second. If this is an intentional tort, we're not obligated for any legal costs. We're not obligated to pay the judgment. We're not obligated to cover the appeal. So they do have kind of a separate issue than Travelers, where they're saying Amber Heard intentionally lied. It was a willful tort. We shouldn't have to cover anymore, no matter what. We shouldn't have to pay toward the judgment. And that's not what Travelers is arguing in their lawsuit against New York Marine. Maybe they'll bring their own lawsuit to Amber if and when she loses her appeal. So back to this. ProCite argues that it would be prejudiced by consolidation. However, its basis for this argument are difficult to understand and unpersuasive. ProCite guesses that the insured, Amber Heard, may seek to stay part of one of the actions. So New York Marine is thinking that she's going to want to hold off their lawsuit until after the appeal. Speculation about what Amber Heard might seek and the court might order is not evidence of anything. Moreover, even if ProCite's speculation is true, it does not prove that the situation would be more complex or prejudicial after consolidation. ProCite also states that a jury in a consolidated case could be confused by the rights of various parties. The thread of this argument is difficult to follow. However, Travelers has every confidence that the court's experience in instructing juries in cases involving multiple parties would eliminate any concern of jury confusion. ProCite does not offer any substantive reasons why consolidation should be denied. It merely speculates on certain possibilities, which in any case are unlikely to cause ProCite any prejudice. The factual overlap in the two cases has recently crystallized. One of the insured's former defense attorneys was scheduled to be deposed in the first action, the Travelers versus New York. He cooperated with the scheduling, but he put the parties on notice that he would likely object to sitting for another deposition in the second action. The insured's personal counsel likewise the insured is Amber Heard, her personal counsel likewise has expressed opposition to witnesses being deposed twice, and he pushed back on ProCite's request that he sit for a deposition in the first action prior to a ruling regarding consolidation. The deponents' positions are indicative of the topical overlap in two cases. In light of the undeniable common questions of fact and law, the court should order consolidation for all purposes. Nothing in ProCite's opposition suggests otherwise. And ProCite did say this, New York Marine. They said, look, maybe for parts of discovery we can work together to pose them one time. ProCite, the lack of input from Amber Heard to date does not prevent consolidation. ProCite also asserts that consolidation should be postponed until the view of Amber Heard can be assessed. This is not a reason for the motion to be withdrawn, as ProCite suggests. If the court would like to hear from the Amber Heard before ruling, it can continue the hearing on this motion and order a response by Amber Heard, followed by a reply from Travelers on a briefing schedule. On a side note, it is not true that Travelers failed to respond to a communication from counsel for Amber Heard regarding consolidation, as ProCite informed the court. Counsel for Travelers did communicate with counsel for Amber Heard more than once in writing, but it did not copy ProCite on those communications. Aha! This is where I think there's a little gamemanship going on. Travelers intended those communications to be private, and it does not provide them here. The insured's counsel was aware of this motion and has not provided any formal objection or opposition to the consolidation. Well, there could be a reason for that, because Amber Heard hasn't answered. She hasn't filed her official answer to her own lawsuit yet. So it might be why she hasn't formally objected or opposed this yet. But there is a time ticking away to file these kind of objections. ProCite's incorrect statement that Travelers did not respond to Amber Heard should have no bearing on this motion. Travelers' case against ProCite, the first action, and ProCite's case against Amber Heard, the second action, should be consolidated for all purposes. The two actions involve the same key factual and legal issues, and they will involve similar witnesses and documentary evidence. Both actions are pending before the same judge in the same court. Efficiency and judicial economy will be best served by consolidation. The court should order consolidation for all purposes under Rule 42 of the Federal Rules of Civil Procedure, and it should vacate the current trial and discovery schedule in the first action. If the court wishes to hear from Amber Heard before ruling, it can continue the hearing on this motion and order a response by Amber Heard, followed by a reply from Travelers on a set schedule. I have not seen that uploaded yet. Here we have a declaration from Travelers' attorney. I'm an attorney, etc. I reviewed the email that is attached as an exhibit to the declaration of James P. Wagner, which opposes Travelers' motion to consolidate two actions pending in this court. The email is from Kurt Passage, whom I understand to be counsel for the insured for Amber Heard in the action filed by ProSite against her. After I received this email on August 25th, 2022, I further emailed communications with Mr. Passage concerning consolidation of the actions and other issues. I did not copy Mr. Wagner on the first further communications. I consider these communications with Mr. Passage to be private, so I am not attaching them as an exhibit here. Thus, the statement in ProSite's opposition and the declaration of its counsel that Travelers has not responded to this email is wrong. Very simply, I did. The factual overlap in the two cases, which are the subject to this motion to consolidate, has been illustrated recently by positions taken by two attorneys for represent the insured. Taken by turn for represent? That doesn't seem to read right. Position taken by attorneys, maybe who represent Amber Heard. One of the insured's former defense attorneys, Sean Roche, he's part of Cameron McAvoy, was scheduled to be deposed in the first action. Mr. Roche cooperated with the scheduling, but he put the parties on notice that he would likely object to sitting for another deposition in the second action. The insured's personal counsel, Jeremiah Reynolds, that's Amber Heard's private lawyer, likewise has expressed opposition to witnesses being deposed twice, and he has pushed back on ProSite's request that he sit for a deposition in the first action prior to a ruling regarding consolidation of the two actions. The deponent's positions are indicative of the topical overlap in the two cases. I declare under penalty of perjury that this is true and accurate. So let me just revisit this order to clarify what's now being allowed, because a substantial part of Travelers has been dismissed. Let me just, this is New York Marines. Yes, Peterson. Wagner is for New York Marine. Thank you, Your Honor. Let me just ask one specific question. During the January 27th hearing, the court commented that if Travelers is merely saying that New York Marines counsel provided an inadequate defense, that there's no standing for Travelers to assert that. That would have to be Amber Heard. Is the court still of that view? Yes. In other words, just a mere situation that Virginia counsel was either negligent or insufficient, but without any prearrangement on the part of the defendant, there is no, the plaintiff wouldn't have standing because, again, the deficient performance would be a performance that was due to Amber Heard in that situation and not to the plaintiff. Okay, and then the other thing I would point out, Your Honor, you may have already answered this in the federal versus MBL case, that the court relied upon in granting the motion to dismiss in part. I guess that was a case where the insured did not allow appointment counsel appointed by Amber Heard, who were not providing cumulus counsel, did not allow them in. The court says in that case, the Amber Heard, the insured who did provide appointed counsel, cannot get their defense fees back. Their only remedy was to go after the insured. So the court is not deviating from its reliance on that case. Is that how I understand it? Let me put it this way. The case speaks for itself, and hopefully what I said about the case is in conformance with what the case said. Because if in some way I have mischaracterized the case, which I don't think I have, but if I can't have, the case speaks for itself and it is the law. Thank you. So let me back up a little bit to where the judge. All right. Going back up. Sorry, guys. Okay, this is where he's making very definite the court. And I have done this in a previous video. That's why. I was going to discuss this with the parties at this point in time because it seems to me there is a question. This is a part of the dismissal. Am I going to require yet another amended complaint, Or is the amended complaint sufficient? And I think that it is. But the other problem is that I can't grant a motion to dismiss on, part of the cause of action. In other words, either I dismiss the claim or I don't dismiss the claim. So if I'm not going to require an amendment, then I would do deny the motion to dismiss, but my further statement that I am not changing my view on is the Cumas counsel issue, and I will not allow that to go to trial or to be litigated further in this case. That theory is ending now. Cumas counsel issue is that Amber Heard should have been able to choose her own lawyer. New York Marine chose Cameron McAvoy. Although Amber Heard had already hired them, they said, you know what? We like them. That's our attorney of choice. We want them to be the lead attorney for going forward. They will represent you. And this was before Travelers came in with their own attorney, which I think was Robbie Kaplan at the time. So the judge is saying that's no longer an issue. You can't take that to trial anymore. The only thing we're moving forward with is that whether or not the counsel that New York Marine appointed, whether they intentionally did no work, Travelers claims, or New York claims they were intentionally left out, and therefore they had no choice but to withdraw. And if they were intentionally left out, they were intentionally, nobody worked with our counsel. New York Marine is saying then that means Amber Heard denied our counsel, therefore we're not obligated to pay anything. So that's pretty much what's happening now. Let me take a look just to help a little bit is in that email. This is the email from Amber Heard's new counsel for these. And it was sent from Kirk Pasish to both Travelers attorneys, her personal attorney, and New York Marine's attorneys. So it was sent to everybody. Peterson, Cappy to Wagner. So both sides got this, including her personal attorney. Gentlemen, as you know, Ms. Heard is not a party to the Travelers lawsuit, has not been served in the New York Marine lawsuit yet. This is back in August 25th. But the policies are her assets, and you are proceeding without her involvement. I note that each of you have reached out to me, but I have not had authority to accept service in the New York Marine lawsuit. Given that the policies are her assets, she clearly is a real party in interest and likely an indispensable party. In other words, she's going to be deposed as a witness in the Travelers New York action. As you also know, Ms. Heard is actively pursuing her appellate remedies in the Depp lawsuit. Your actions are forcing her to litigate on multiple fronts and increasing the stress upon her. This is not an appropriate way for insurers to treat their insured. Because Ms. Heard is not a party to Travelers Travelers lawsuit, she has no meaningful way to assess whether it is appropriate to consolidate the two lawsuits or what any prejudicial impact may be from consolidation. She also does not know what has transpired to date in Travelers' lawsuit, including what discovery may have been conducted, although she is aware that certain discovery is being directed against lawyers that have represented her, which may itself be prejudicial. I suggest that you, New York Marine's counsel, and I have a conference call to discuss this. Meanwhile, we request that you withdraw your motion to consolidate until we talk. Please note that we are not saying at this point that the lawsuit should not be consolidated. We are simply asking you defer the motion until Ms. Heard and we have a chance to consider what has transpired in the lawsuits. If you are not willing to do so, please advise us so that we can take steps to protect Ms. Heard's rights. Also, to the extent you intend to proceed at some point with a consolidation motion, please provide us now with copies of all filings and orders in the case, all discovery conducted to date, including transcripts of any depositions and all future deadlines and any other events. Meanwhile, Ms. Heard continues to reserve her rights. Now, one of the things they talk about is whether or not Amber Heard has been served. And I can show you her lawsuit. This is New York Marine General Insurance versus Amber Heard. And I've got to scroll to the bottom, guys, so watch your eyes. And down here, what you'll see is a notation. Filed September 23rd, notice and acknowledgement of service of summons and complaint, returned, executed, filed by plaintiff New York Marine General Insurance Company upon defendant Amber Heard, acknowledgement sent by plaintiff on August 31st. So on August 31st, when it was issued, it had an automatic 14-day answer time, or 21-day, 3 weeks basically. Her answer was due September 21st, but because she did not notify until September 23rd, those dates obviously are going to be extended. But it pretty much says acknowledgement of service signed by Kurt Passich, counsel for defendant Amber Heard. So it looks like at least on this date, she's been served. Now, I would expect a reply anytime. This is tricky because this is in the related motion. This is the reply from that I just read. So it's not from them. So that's a little bit brought that together for you guys. And that's where we're at. So Travelers wants to consolidate with Amber Heard's lawsuit. And I think they really want Amber Heard in. Even though they're two separate lawsuits, once they come together, they'll still be tried as two lawsuits. It can get confusing, but I think they want Amber Heard's testimony to the jury that maybe throwing Cameron McAvoy under the bus might help out Travelers. So that's where I'm at with that. I hope that hasn't been too confusing. I have a playlist of prior videos that I've done. I hope you'll take a look at. And thank you for stopping by today. I will put all the document links in the description, as I always do. Thanks, guys, and have a great day.